Welcome to Infringe at Your Own Risk.
Hello, everyone, and welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. My name is Sean O'Connor, and today Rand and I are talking about who actually owns an invention when it's created inside a company, especially when employees, independent contractors, or outside collaborators are involved, something that's, increasingly prevalent, it seems. Rand, good to see you.
It's good to be seen. Sean, how are you doing?
I'm doing good. And
Great.
let's talk about, when a company hires someone to design a product or develop a new technology, what determines who legally owns that invention?
Okay. This is really important, and it's probably one of the places where small companies create potentially huge legal liability for themselves. Work is typically owned by the creator. And the creator, if you're an employee, the creator is your company, usually, if it's within the scope of your employment, right? I mean, if you're hired to be a janitor and you suddenly, on at night code up something really cool, then pretty good argument that it's not. But if it's within the realm of your work and you're creating for your employer, the employer usually owns that that invention, that writing, software, whatever the design is. And there's different states have different specific formulas on how you weight that. If you create something that's not relevant to your employment, but you use any of the assets of your company to do it. So let's say you're, on your lunch break, you're sitting at your work computer and you write some software. You may maintain ownership, but your company may get what's called a shop right, which means they get to use it for free. They don't own it, but they get to use it for free. And those are very fact-intensive cases to determine whether the employee should own it, whether the employer should own it or not. Where companies get in a lot of trouble is they hire somebody to prepare something for them. And by hire, I don't mean hire as an employee, but they retain a company or a person to do something for them who is either an independent contractor or a separate company.
Mm-hmm.
And that gets challenging because, as I said, the person who creates the work usually owns the copyright in it. So if I hire someone, I pay them $100,000 to write software to manage my warehouse, let's say. They create this great software that's wonderful. And a lot of companies will say, well, I own it. I paid for it. No, you own your copy of the software that you get to use to run your facility. But the person who created that owns the copyright typically, unless one of some exceptions we'll talk about. Where that becomes problematic for companies is sometimes the company is using that software or whatever it is and sending it out to other people, like to their customers, right? Download this app. Okay, so you download the app. Okay, well, do you have the rights to have other people have the app on their phone? Now, you could argue it's implied because the only reason you would have an app is for your customers to use it. But by far the safer approach is whenever you hire anybody to create content of any type, whether it's or content or software or anything like that, is you need to spell out who owns what and what the expectations are that you can use it. So it's if I have somebody write me an app, I'm going to have a license that I can distribute the app to anybody I want to distribute. Okay, that's a kind of a bare minimum. Or I want ownership of the app. And the reason I want ownership of the app is they just wrote me a really cool app. That independent contractor could go across the street to my competitor, change a screen or two, and have the competitor doing the exact same or very similar app to my app. And why that's upsetting is I paid the guy $100,000 to prepare it. and my competitor just paid 10 to get a copy. And it's, it's almost free money to him. It took him an hour to change the front page to look like his company instead of mine. And so the guy I've just paid 6 months worth of salary and all that too sells it. So you want, preferably as a small company or any company, if you have people create content, you want ownership of the copyright. If you can't get that, you want restrictions on what they can do with that material. Okay. And you can say, look, you can go out and create other apps, but you can't sell to anybody in our industry. Mm-hmm. That would be kind of the next best thing. I don't care if you go out and make profit off it by selling it to people we're not competing with, but we don't want our competitors to have something this good that we've just paid a whole bunch of money to you for. So you need to think that through early on and put it in your agreements, because if the app is really successful, that developer is not going to want to give you those rights after the fact, especially after they've already been paid, right? Once your check is cleared, they have zero motivation to give you those rights. So make sure you're getting those rights up front. Another place where you get into trouble is if you hire, a lot of small companies will hire people as independent contractors. I know it's virtually impossible now in California, but everywhere else, it's a way that people save money. I don't have to pay benefits. I'm not liable if they do certain things. And so they'll hire people as independent contractors. The problem is if that person is creating materials that you use, they may own the copyright. In fact, there's one of the famous copyright cases that happened back just before I was in law school is Community for Creative Nonviolence versus Reid. And Reid had created a statue for CCNV that they were going to display. Well, it became very popular, so people wanted to make like imitations of it and stuff. And Reid goes, no. I own the copyright. You own the statue. I own the copyright. So if anybody wants, and so they litigated, and they found, sure enough, Reid was not an employee. He had been an independent contractor. He had controlled, one of the things they look at is who controls when it's done, who controls how it's done. If you just tell somebody, here's 10 grand, go create something for me, they're going to be an independent contractor and they're going to own the copyright. Yeah. If you say, all right, here's an office, here's a computer, and I'm paying you $5,000 a month to create this, and here's your parking garage pass, and here's your benefits, then it's going to be most likely found to be a work of the company. So when you're doing that, you need to make sure it's clear who it's going to be owned by and whether it's a work made for hire. Now, a lot of people use work made for hire much broader than it actually means within the copyright thing. But the important thing is get an assignment. If you're paying somebody a lot of money to create something for you, the agreement should read, I own the copyrights, right? So then they can't hold it over your head. And I've had clients who, they were doing creative stuff, creating, say craft materials. Well, they were using them, and this person, it was kind of unclear, are they really an employee or are they really an independent contractor? Well, then the stuff takes off, and then all of a sudden the person goes, oh, I was an independent contractor and I have the copyright, and you have to pay me if you want to expand into other mediums. A lot more expensive. Back then it's like, oh, these were just some cute little things she designed for us and not really a big deal. And it's not worth the extra hour to go through and write up a short agreement on who owns what. But then when you're doing millions of dollars a year in that, the motivation of that artist to be an independent contractor and never have assigned it become much stronger. And you end up litigating it. And I've had to litigate cases like that where companies thought they owned everything. And that case, we prevailed because we showed that she actually was an employee. But
is that what it comes down to in terms of, when there's, there maybe is no explicit or comprehensive written agreement, do courts typically evaluate ownership or assignment based on, independent contractor versus, smells like an employee, walks like an employee, talks like,
Exactly. if you're paying their taxes and giving them benefits, you're probably going to win.
Got
Right.
it.
I mean, because you're treating them like an employee. If you're treating them like an independent contractor, you're probably not. The way to avoid all of that is just have a nice agreement. It doesn't have to be fancy. As part of this agreement, company is going to own the copyright.
Yeah.
Right. And so once you get that, you have ownership. One of the things I love doing when I'm working out on the farm is I listen to various, Reddit stories and whatnot. And it's always funny you hear the one about the person who, they're working at the company didn't respect them and they filed their patents, and so all the company's technology is in their patents. Well, normally that wouldn't happen because they would have a duty to assign. If that's part of their job is developing that type of stuff, those patents would typically be owned by the employer, not by them. But if you have an independent contractor who is doing stuff, they may create stuff that's patentable, that's outside of what the company would own. And that can be problematic if you're moving your company in direction of a certain technology and the independent contractor that you've been paying, low wages and no benefits, turns out they have a patent right in the middle of where you want to go. That can be really problematic. So if you're going to hire anyone as an independent contractor or not clearly an employee and within the scope of their work, get it in writing that that it's going to be assigned, you're going to own it, they're being compensated for it.
Well, in the case of the patents, I know we've spoken before about, the need to name the inventors, so to speak. I mean, I have friends who work in technology and they own several patents, but and they were developed while working at the big tech company.
Yeah, they could be an inventor, but they wouldn't own the patent.
Got it.
Right. But for an inventor, if you're in electrical engineer or engineer of any sort, to have a bunch of patents in your name is a big deal.
Yeah.
It increases your value when you're out looking, I'm leaving this tech company, I'm going to that tech company. Oh, I've got 47 patents, or I'm a named inventor. I mean, that
Yeah.
tells the incoming person, this person is forward thinking, they're solving problems. I want this person.
Yeah. What about joint ownership? I mean, joint inventorship. How do those rules complicate ownership? When multiple people have contributed to an invention, it's often a team sport, right?
Yeah, and sometimes you get fragmented ownership because normally each inventor owns an undivided interest in the patent. Okay. But if 3 of the inventors are for company A may own it based on their duty to assign, but they would still own it. But inventors C and D and E who aren't from their company, let's say they're from another company, they may have rights in it, or their employer may have rights in it. And sometimes you get patents that are jointly owned where, GE and Hitachi may both be owners of the patent, because, their employees kind of worked in a joint venture or something. With a patent, the value of the patent is exclusivity. And if you have joint owners who are somewhat adverse to each other, it can be problematic because any owner can license whoever they want. So if I and you own a patent together and you say, hey, Rand, company X is infringing our patent, let's go sue them. And I say, no, Sean, company X is owned by my wife and I don't want that to happen. I'm just going to give her a license. And then you're kind of screwed because the inventor can give it away.
But also, right, you could unilaterally decide to license, collect fees, right, from company X without my involvement whatsoever. Unless we have some agreement that says if you do any licensing, then, we share that stuff. But
yeah, and there's provisions in the law for various things where you have to make an accounting if you license people. But, if I own a company that makes computers And I really don't want anyone else having this cool thing that we've done, but you're a joint inventor. You can take an awful lot of my value away by saying to my competitor, oh yeah, you can license that and just pay us 10 grand. So joint ownership of patents is often a bad idea because one party can kind of negate the value of the patent very easily.
Yeah, it's
better to do it. And I recommend, people will, two friends will get together, they'll file the patent, and I recommend usually put it in the name of the company. Start an LLC, put it in the name of the company, because LLCs and different corporations, there's rules on how you divide the assets if there's a fight between the owners.
Right.
Whereas if they're just jointly owned, either party can go do whatever.
So that's interesting. I wanted to ask you, and with just the few minutes that we have left, from the businesses out there, business owners, entrepreneurs listening, they're growing and hiring engineers or product developers right now. What are a few practical steps they should take to prevent ownership disputes down the road? You just mentioned, hey, you and your buddy ought to do an LLC because there's rules inherent or implicit in the LLC. What other best practices would you recommend?
Well, if you're a corporation and you're hiring people, you want something in your employment letter that says if you're working on stuff for the company and you invent something, we own it, and you're agreeing to that. Because people, well, I created this. Well, yeah, but you're creating it with all the knowledge you're getting at your work. You're using that stuff. So you want to put that, but avoid the extreme, right? Where, the guy who's working on your back dock unloading semis, he probably not a big IP threat, unless it specifically relates to your company. But just doing your paperwork, and a good business law attorney is going to have good forms for onboarding people. Here's what it is. And then when you offboard people, remind them of their duties to the company. You say, look, I'm not trying to be mean, but you need to remember this is confidential information you can't disclose. This is these patents, even though you're a named inventor, they're owned by the company. So you can't use this technology at your new company if that was your plan. And, there are $1 billion cases where somebody walks out the door with the technology, and then the company says, oh, you can't do that, and sues their new company. And nobody wants to hire somebody and then have that person be the reason that they're in a multi-million-dollar lawsuit.
Right. Good stuff. Well, Rand, as always, great to talk to you.
It's good talking to you, Sean.
Yeah, thanks for sharing your knowledge. That's it for today's episode of Infringe at Your Own Risk. Thanks for listening. And if your company is developing new products or technology, make sure your ownership rights are secure before a dispute arises. Visit batemanip.com to connect with Rand and his team. And don't forget, subscribe, leave a review, or share this episode with a colleague who might benefit from it. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.